practiced for a while in DC.
Uh,
I actually started out in trade, and I still did trade law.
where were you practicing?
Fully in larger.
Okay.
It goes early 90s.
Okay.
Been a professor.
Oh wow.
I was at Georgetown on sabbatical 3 years ago.
Okay. Teaching trade.
Teaching, actually, what else was I teaching? I was teaching a course on comparative corporate governance. I think I did, and introductory course on Korean law.
Oh wow. Was there a big audience for a course on Korean law?
Actually, there's a lot of Koreans.
Right.
Chico.
More than you think.
Yeah.
But
Wow.
of course, the big focus.
Right.
You were at USGR for a while.
I've moved around a lot. I was on the Hill for a number of years.
Okay.
And then I was
We
at
got a copy.
USPR.
Okay.
And then I was
10 minutes
at
ago.
the National
A copy
Security
arrived.
Council.
Oh,
Did you
wow.
see that?
And then I
Oh,
left
that's
government
yeah,
office.
that's
If we could
Jean.
have everyone begin taking their seats, we want to start on time or as close to on time as possible. So everyone can come on in.
He is.
Oh yes. Okay. Well, good morning, everyone, and I'm so pleased to see so many of you have made it to the Wilson Center this morning. I'm sure you all are trying to figure out how federal government speak works and what is a 2-hour delay, and we're just grateful that so many of you were able to make it this morning. I specifically want to thank my staff for getting everything together here and ready. The fact that there was coffee and tea available should be considered a federal miracle. You should not anticipate, for those who have lost faith in government and how well it works, that is an example of government working very well. So I'm very grateful that we were able to welcome everybody here in the style that we normally do. My name is Will Pomeranz, and I'm Deputy Director of the Kennan Institute here at the Wilson Center, and I am pleased to welcome you here to this living memorial to our 28th president. Woodrow Wilson is the only U.S. president who also had a PhD, and the idea behind the Wilson Center is to create a link and a bridge between the world of ideas and the world of public policy so that these ideas have a broader impact on the public debate. Since I'm sure most of you are not aware of or haven't had a chance to visit the Wilson Center before, we have a very active scholarship program with scholars in residence. We sponsor numerous events and really serve as a neutral forum in Washington, and that is really one of our great advantages. In a very partisan town, it's very important to have such a space for discussion. And all these events are open to the public. And you are welcome to follow us on the internet, on Facebook, on Twitter, and so forth. And there really are a lot of very important meetings and ideas that are discussed here at the Wilson Center that would be of interest to you going forward. We do have a variety of programs at the Wilson Center. Several focus on individual regions. The Kennan Institute, for example, focuses on Russia and the former Soviet Union. And we also have programs dealing with certain thematic issues, such as the environment, urban affairs, energy, the Cold War History Project, which has unfortunately become more relevant with the passage of events, and so on. But one of the consistent trends here at the Wilson Center is a discussion of legal and rule of law issues. Indeed, they touch many of the programs and much of what we do. Some of them are dealt with internally within each country or region, dealing with the development of legal institutions or constitutionalism, human rights, and so forth. But the Wilson Center is also very interested in the broader legal issues associated with globalization, whether they be privacy, anti-corruption, offshore banking, and so forth. So today we are especially pleased to partner with Jean Kalitsky and the International Center for Settlement of Investment Disputes to discuss possible reforms to the current system of resolving international investment treaty disputes. And I should say that as a lapsed lawyer, I'm particularly interested to catching up and seeing what I've missed over the past few years. But I think in the broader sense, it is critical to bring these rule of law issues into the broader domain of public policy. Often they aren't discussed in the detail that is necessary, and that is why I'm so pleased to host this project and to see all of you here today. And I hope the Wilson Center will find new ways to engage with the legal community. And with that, I will pass it off to Jean.
thanks to Will, and I have to say on behalf of not only of myself but also my wonderful co-editor Anna Jupin-Brett, we are very grateful to the Wilson Center for hosting us, and particularly to Will and to his colleague Madison Brady for making all of this possible, particularly in the snowstorm, or what passes in Washington for a snowstorm. Woodrow Wilson's presidency was marked by a particular commitment to international law and international organizations, and it therefore seems particularly apt to hold this event here today, since the whole focus of our book is on processes for using international structures to resolve disputes between states and investors. We also wanted to thank TGM and OJMID and Brill, who are our publishers, for support of this initiative. Mark Canner, who's hiding somewhere here, was really the godfather of this project, a title that I enjoy bestowing upon him. And he worked together with Anton Henson of TDM and Marie Sheldon of Brill, who's also here to help Anna and me turn it into something which was far bigger than either of us ever imagined. And I say that quite literally because I saw the book for the first time 15 minutes ago. With the index, it clocks out at over 1,000 pages, so it makes a good doorstop, if nothing else. It is weighty. In any event, we could only feature on today's panel a few of our several dozen contributors, but I did want to call out those other chapter authors who I believe are attending today, just so you'd have a small sense of the wealth of knowledge and insight that went into this book. There are many chapter authors not here today as well, but I think in the room today, in addition to Meg Kinnear, who you'll be hearing from in a few minutes, and our four panelists, we have, I think, Antonio Parra in the room, Adam Raviv, Amal Bukanaki, Unyoung Park, Jose Antonio Rivas, J.J. Solino, Christoph Schroyer, Jeremy Sharp, Baiju Vasani, Eduardo Zaleta. That's just a small taste of the authors who've contributed. Those are just the ones who were registered for today. We brought together 50 or 60 different viewpoints, which was really our goal. And we think the topic of the book couldn't be more timely. Most of you will be aware of the intensifying debate in Europe right now about investor-state dispute settlement, including whether even to include ISDS provisions in the TTIP, the Transatlantic Trade and Investment Partnership Agreement being negotiated between the EU and the US. And of course, there's also been disquiet from certain parts of Latin America and in a few other regions. And yet, as an UNCTAD report that was released just in the last week or two documented, the number of new investment agreements is actually rising. And even those states that have expressed concern about the existing structure are generally not withdrawing from the treaties to which they're party. And so the result is that the overall regime of investment arbitration will be with us for a very long time. And that puts a premium on enhancing the dialogue about how to improve that regime, rather than a sort of a false dialectic between the unlikely extremes of scrapping it altogether or complacently assuming that no change whatsoever is needed. And so that was the starting point for our book. And we strove to organize creative ideas that were focused on practical ideas for improvement. And we put them into three loose buckets. First, proposals to strengthen the involvement of states, either in treaty interpretation or in revising treaty provisions. Second, the idea of more fundamental structural reforms, more use of state-to-state procedures, regional courts perhaps, or appellate mechanisms. And third, reform from within the existing system through institutional rule change or encouraging innovations by tribunals in their management of proceedings. And so our panelists today have contributed ideas that span all three of those loose buckets. Tomoko's chapter is in the first part of our book. Ted's and Bart's are in the second. Jungi's in the third. And we thought that together they could give you a great cross-section of ideas and perhaps a little teaser for you to read other chapters as well. So before I turn things over to Anna to kick off today's program, we are very pleased to have some welcome remarks from Meg Kinnear, who, as you know, is Secretary General of ICSID and who contributed the foreword to the book, and also arranged for ICSID to co-sponsor today's event. And Meg, as you know, has brought to ICSID a wealth of new ideas, of practical initiatives, administrative efficiency, an open mind, and a deep commitment to dialogue and to forward movement. And although ICSID will always, by definition, attract some critics, I think both Anna and I wanted to make the broader point that Meg, more than anyone else we know, has really been motivated by the interests of the institution over which she presides and the interests of the system and of all of its users and stakeholders. And I know I speak not only for myself and Anna, but for many others in this room, in saying how indebted we are to Meg for her service and how inspired we are by her example.
Well, thank you. I'm delighted to be here. I would like to give congratulations to Jean and Anna for pulling together this remarkable text in remarkable time. I think their timing is exquisite, not only in terms of production time, but more particularly in terms of the current discussion we're having on investor state and international investment arbitration. I will be succinct this morning because I very much, like you, want to hear the speakers and hear the discussion of options. So I wanted to make 4 short points as a bit of a background to this discussion. The first, of course, is that investor-state dispute settlement and international investment agreements have shown an extraordinary capacity to evolve. We have had this discipline for only about 50 years, and we've truly had hands-on experience in terms of actual cases and outcomes for about 25 years at most. Nonetheless, in that short time, we have seen huge changes. For example, there are the ICSID 2006 rule changes implementing transparency provisions, and more recently, the UNCITRAL Transparency Annex, and this March, the Mauritius Convention. All of these are huge sea changes in the way our profession is doing business. So I think this kind of change that we have witnessed to date is something that should make us optimistic about the potential to reform and make the system better as we keep what's good in the system. Secondly, as we look at these issues, I think perhaps we should think about the format through which change can be achieved. We as good lawyers often think about a treaty amendment or a rule amendment when we talk about change, and that of course is the dramatic and lawyerly tool to accomplish a change. But we also know that a number of the most significant and effective initiatives that we've had have been almost soft law type tools. I think probably the premier one we would all think of are the IBA guidelines on conflict of interest. And so successful change can come not just through hard convention, rule, etc. amendment, but also through some of these practice guidelines and those kinds of issues. And I know certainly at ICSID we have initiated a number of practice guidelines which have had a real impact, and stakeholders have said we very much appreciate this. One example is a ballot form that we're now giving to try and bring forward new arbitrators into the system, and we've had huge appreciation and huge acceptance of this ballot form. So soft law and practice change should be part of the scenario when we're talking about reforming the system. The third point is the who, in terms of who can affect change, and that is critical. We quite legitimately very often look to states, and certainly states have a huge and important role in making changes. They are the ones who define the obligations and define the remedies in the treaties. Similarly, we often hear discussion, the institution should make us behave in one fashion or another. And again, at times, sometimes that is a very logical reaction and certainly part of the role of institutions. However, in this discussion, we should include the parties, what the council and the arbitrators, as the stakeholders and as, frankly, the people who are most responsible for how this works. We should ensure that they are both part of the discussion and part of making whatever implementing has to happen for new reforms happen. So let's bring in the whole community for this discussion, and an event like today is superb for doing that. Finally, I wanted to make a plea for rigor in this discussion. Too often, the conversation on investor-state dispute settlement reform or investment arbitration treaty reform proceeds from assumptions or premises that are misleading or even plain wrong. And if we are going to be constructive, our analysis has to be about what does work, what doesn't work, and how a proposed change would make things work better. So the plea for rigor, I think, should be throughout our discussion. And I look forward today to hearing the discussion of the panelists. I know they all bring great rigor to this and great creativity to this whole area. And I look forward with them and with you to being a part of our evolving future in this important discipline. Thank you.
Thank you very much, Meg and Jean, for launching this event and for starting the discussion. We have structured this morning's event in the form of a panel where each of the panelists will present the substance of their contribution, their ideas, their proposals to reform of the investor-state dispute settlement system. And we will have, hopefully at the end of this these presentations, we'll hopefully have an active debate also with you in the room, because we took this approach, as Meg was saying, we took the approach of really looking for proposals, looking for the future, looking at privileging practical ideas much more than, the hand-wringing or the criticism or the saying this is broken, this needs to be fixed. We really tried to look beyond that and look at what could be done, and we really ended with a broad menu of options, of thoughts, of contributions from all our contributors. We have 4 of them today. We selected a few of the topics, but as Jean said, there are many other contributions that really take us very much to look forward, what can be done, what can be, how can, from a very practical point of view, how can the system be improved, how can it evolve? And so that's what we really want to hear from our contributors in the panel, and then hopefully also exchange with you. So I'm going to start to kickstart these presentations with a presentation from Tomoko Ishikawa. Tomoko is an associate professor at Tsukuba University in Japan. She works and researches on international economic law, and she's also former deputy director of the International Legal Affairs Bureau in the Ministry of Foreign Affairs, so at the treaty negotiating side. And her chapter will take us through keeping interpretation of investment treaty arbitration on track and emphasizing the role of the state parties, proposing the inclusion of a formal mechanism to using joint interpretative statements as a way to achieve balance between the interpretative powers of the states and investors' rights to due process. Without further ado, you have the floor, Tomoko.
Thank you, Anna. First of all, I'd like to express my sincere gratitude to Jean, Meg, Anna, and the Wilson Center for inviting me to speak with such distinguished panelists and the moderator and the keynote speakers. My chapter focuses on the role of states in interpreting investment treaty provisions. The first part of my chapter demonstrates the increasing need for states to exercise control over the interpretive discretion by arbitral tribunals. This is because in certain cases, arbitral tribunals have produced interpretations that are inconsistent with the intention of state parties. In order to illustrate this point, I pick up a series of recent arbitration decisions that I think expanded actually the scope of the subject matter jurisdiction, which goes beyond the accepted framework envisioned by the state parties. Then, as a means by which a treaty party generates state practice that tribunals could take into account when interpreting treaty provisions, I propose a mechanism for issuing joint interpretative statements as subsequent agreements on interpretation to be included in investment treaties, which is, however, distinguished from that under NAFTA. So my chapter examines the jurisdictional decisions of the cases, Argentina sovereign bond cases, 3 cases, Abaclat, Ambiente, and Alemani cases, and the Deutsche Bank versus Sri Lanka case that arose out of the hedging agreement between the investor and the state-owned petroleum company. I do not have the time to go into the details of these cases, but I would like to emphasize that they did share a common question, that is, whether or not the security entitlements deriving from these contracts, sovereign bonds or the rights under derivative contracts at issue, qualified as an investment within the meaning of Article 25 of the ICSID Convention and the relevant investment treaties. Apart from the recent Alemani case, in which the tribunal joined part of this question to the merits, the majority of other cases answered to this question in the affirmative. Although prior to these cases, there had been investment arbitration cases where public financial instruments were found to be qualified as investments under the ICSID Convention, such as FedEx, CSOB, and Alpha Project Holding cases. My argument is that the Abaclat and other cases are not in continuation with the FedEx and other cases, but rather they expanded the scope of the notion of investment. Because the Abaclat and other cases could be distinguished from the FedEx and other cases on several accounts. For example, the contracts underlying the financial instruments for Abaclat and Ambiente or Deutsche Bank cases were governed by the laws other than the laws of the host state. For example, the English law or the New York law. And also for Abaclat and Deutsche Bank cases, the investors' rights were justiciable before local courts of a third country, meaning the courts other than those of the host state, such as the English High Court or the International Commercial Arbitration, or like the Southern District Court of New York. So these elements led me to conclude that the Abaclat and other cases actually expanded the notion of investment to include the investor's claims in relation to which the host states act as a party on equal footing to the relevant contracts. So this is where these Abaclat and these recent cases could be distinguished from the older FedEx when CSOB and Alpha Project Holding cases. Another development of law that may result in the expansion of the subject matter jurisdiction is the incorporation of an umbrella clause by a most favored nation clause. I actually in my chapter contest this approach, but this appears to be possible following the EDFI versus Argentina or Arif versus Moldova tribunal's approach. So what's the implication of these cases? My argument is that the combination of the approaches adopted by these tribunals could result in a dramatic expansion of the subject matter jurisdiction. That is, there may be now cases even where the host state acts on equal footing with the creditors in contractual relationships. Allegations of a breach of any obligations of the state undertook towards the other party to the contract are found as a prima facie case to give rise to subject matter jurisdiction. Given the controversial nature of each tribunal's approaches, as illustrated by strong dissenting opinions accompanied by each of these decisions, I argue that such a consequence would, in many cases, come as a surprise to state parties. So I would like to then consider ways for states to prevent tribunals from adopting such off-track interpretation. I propose that states should influence the interpretation by tribunals by concluding subsequent agreements on interpretation. And I particularly focus on the assurance of joint interpretative statements by the contracting parties, because it is only means that may clearly demonstrate the concordance of all the parties to the treaty interpretation and may therefore fall within Article 31A, 3A of the VCRT. A recent case in which such a subsequent agreement on interpretation was discussed is the Laos versus Sanam case before the High Court of Singapore. I do not have the time to go into the details, but the judge, the Singapore High Court judge, did state, although somewhat ambiguously, that the two letters exchanged between the Chinese embassy in Laos and the Laotian Foreign Ministry, the Ministry of Foreign Affairs, as to the scope of the application of the China-Laos BIT signified the subsequent agreement under the Article 31, Paragraph 3A of the Vienna Convention on the Law of Treaties, and did conclude that the Laos-China bilateral investment treaty did not apply to Macau, which was the issue in investment arbitration. However, subsequent agreements are by no means uncontroversial, especially the feature of investment treaty arbitration that the disputing parties do not match the contracting parties to the treaty may give rise to the issue, the question of fairness of subsequent agreements. This is because if the treaty parties may effectively modify the language, the treaty language, by subsequent agreements on interpretation, that may well not only create unfair surprise to the investors, but also potentially undermine the claimant's investors' rights to due process. This issue was actually discussed in the Pope and Talbot versus Canada case. But this concern over due process arises where a joint interpretative statement is issued after the commencement of an arbitral proceeding. So thus, if the states could issue interpretative statements before the dispute which arose is actually brought to investment arbitration, such potentially unfair consequences actually to the investor would be, at least to a certain extent, avoided. Moreover, if the state agree on issuing a joint interpretative statement before the commencement of an arbitral proceedings, such a statement can provide the investor with a basis for deciding whether or not to bring the dispute to arbitration. So I propose to use the consultation period requirement the many investment treaties have as a jurisdictional or procedural requirement for the commencement of arbitral proceedings. So in the consultation period, the investor, disputing investor, and the disputing host state are required to settle the dispute amicably through consultation within a specified period of time. And I propose to employ this period of time for a dialogue on interpretation between contracting states in tandem with the consultation between the investor and the host state. The interpretative consultation between the host state and the home state can also take place during this period. So I admit that a significant challenge to this proposal is that the success of the operation of such mechanism actually depends on the political will of the contracting states, and political considerations may prevent the investor's home state from having recourse to such mechanisms, which may well conflict with its own national interest. However, in view of ongoing negotiations of mega free trade agreements such as TTP or TTIP, states should recognize that investment treaties do cut both ways, in the sense that today's home state may be brought to arbitration tomorrow. Such recognition would enhance their role in treaty interpretation, thus avoiding surprising consequences. By way of concluding my presentation, I would like to stress that for sustainable development of the investment treaty arbitration, what is required by both states and tribunals is a clear recognition that the responsibility and the power inherent in treaty interpretations must be shared by the contracting states and the arbitral tribunals. Thank you very much.
Thank you very much, Tomoko, for this excellent presentation. How do you see that evolving? We know that treaties increasingly include language to allow the state parties to consult on some specific issues, for example, on taxation or other specific areas. There is a mechanism inbuilt in the treaty. How do you concretely, do you see that in the treaty language? How would you propose this to implement this change?
The treaty language, okay. So, for example, the Japanese investment agreements I negotiated when I was working with the Ministry of Foreign Affairs, we do have several provisions which are modeled on the NAFTA 1131. You know, the interpretation by the joint committee shall be binding on tribunals. But with the exception of the Free Trade Commission, NAFTA Free Trade Commission's interpretative note, and although we have Senam and several other cases, the explicit interpretative agreement remains still rare. And the paucity of interpretative agreements may be explained by the political will of the state parties, but also it's without a formal mechanism for issuing joint interpretative statements, it would be really difficult for the home state to actually engage in such interpretative dialogue and issue a statement of interpretation. So I'd like to propose the inclusion of a formal mechanism which is supposed to take place during the consultation period for such interpretive dialogue. And in addition to that, the recognition that interpretative dialogue between the states and arbitral tribunals militates in the long run in favor of both investors and the host states, because it will create predictability and provide guidance on future prospects. Will encourage, I hope, the states to play more active role in the interpretation of investment treaties.
Thank you very much, Tomoko. I'm moving to the other side of the table, although I'm staying within the same chapter and the same region. And I'm turning now to Professor Jong-ji Kim, Professor of Law and Associate Dean for International Affairs at Yonsei Law School, who is the author of the chapter on streamlining the exit process, new statistical insights and comparative lessons from other institutions. We have in this chapter a wealth of data and statistical information on key stages of the exit process. It's interesting to see that we have, by the way, another author, Adam Raviv, who's also with us here today, who also took this approach of looking at empirical data and basing proposals for improvement on empirical data and research. So without further ado, I'm giving you the floor, Jong-ji.
Thank you, Anna. It's a great pleasure to be here. I'd like to thank Jean, Meg, the Wilson Center as well. I, as Anna just suggested, took a kind of statistical approach to this. I had some basic ideas as to why is the process taking so long, and what were the areas of potential reform. So my basic starting point basically was, how long is this process going on? And then my second issue was, who's responsible for this taking so long? And then the third point would be as to what we could do to try to improve the situation. So as we know, we only have basically ICSID statistics. Of course, so therefore we cannot include other major institutions. So I just limited my analysis to ICSID. And then I'll just try to briefly kind of highlight some of the main points that I kind of distilled. I'd like to thank, of course, my research assistants, because it was a very, very laborious task doing all the statistical analysis. So the first interesting thing, we have so far, the only previous study that I was aware of was by Anthony Sinclair in a GAR article in 2009. And in Anthony's article, his data came up with the average case, this would be for tribunals, was 3.6 years. So basically, I kind of built upon that and saw my final conclusion for a total amount of time is actually 4.1 years. So it's a bit longer for the total history of ICSID. But there are a couple of things we have to note that are different. One thing that Anthony did was he based the starting point on the request of arbitration. So that brings it back even further. So what I did was start from the date of registration. And I thought this was more important because I wanted to really focus on particularly whether tribunal, how responsible potentially the tribunal was. And my thought was the time before the actual registration is usually attributable to the parties, because a lot of times they don't do the filing properly, and they need to supplement the process. So I started from the date of registration. Second point to know in terms of time is it kind of peaked. This is if you start from the date that the cases were filed. It peaked in 2003 and 2004, where the average cases were taking more than 5 years, 5.3 years to be exact. But more recently, interestingly, and I actually updated my data up till this month, and it's still pretty consistent, is up till 2008 and 2009, it's back down to about 3.7 years. So that's a hopeful trend. What I did also that's different from Anthony Sinclair's paper is I actually included pending cases, because I thought that was important, because you have a lot of long pending cases. But of course, those are pending, so that would, once they're finished, that's going to add even more time. But that's just something to note. Okay, the second point, therefore, then was who's responsible. And as we know, for many, many cases, particularly across the board, it's largely, a lot of times, it's the parties and the council, for whatever reason, various reasons, are largely responsible for a lot of the time. So a couple of areas to focus. One was, my initial thought was the registration process. And I looked at the registration process, and over the past couple of years, ICSID has done a tremendous job in improving the registration process, and it's very quick now. And the average, according to ICSID, is 23 days. So I think there's not much to talk about here. The second area then was constitutional tribunals. And here I found that from the date of registration until the actual constitutional tribunal, it was actually 204 days. So it's definitely over our target 120 days. So then I was thinking, so why is it taking so long? And then for what I found was basically, it's not necessarily that ICSID is taking so long, it's more that the parties are taking so long before they get to ICSID. Because what we have is from ICSID, once ICSID receives a request, when they have to finalize the composition of tribunal, it actually only takes 46 days. which is their target is 30 days, which is so it's not substantially over. So the other 160 days roughly are basically parties are trying to work it out and they're trying to come to an agreement. So therefore, and of course that's before the tribunal's been constituted, so tribunal's not responsible for that, and ICSID's not responsible for that. So here I found data shows that the parties are pretty much responsible for a lot of that time. The third area then I wanted to focus on was what happens after the hearing. Because once you have the hearing, you figure the award's going to come, should come. And then what I found that in total, it's over the historical average was 389 days after the last hearing, whether it was the merits hearing or it's a jurisdiction hearing or the quantum hearing, whatever what the last hearing was. On average, it was 389 days until the award, which is over a year. So then I was thinking, wow, that's a long time. But then digging further, you see a lot of reasons why this is taking such a long time. And it's not necessarily because the tribunal is taking a long time. Parties ask for more evidence. Parties ask for extensions. Parties challenge the arbitrators. You have post-hearing briefs. You have hearings, briefs for statement of costs. So these things account for a lot of that time. So I don't think, from my perspective, that should be the responsibility of the tribunal, because they're continuously receiving more information. So basically, therefore, I was trying to figure out what could be done. So I looked at other institutions, and basically 3 places I kind of looked at that were interesting. And the 3 were the WTO, Stockholm Chamber of Commerce, and ICC. And basically what they do is they emphasize, what's not really emphasized in ICSID, is the closure procedure. So as we know, at ICSID, closure is something that the tribunal decides. We decide proceedings are closed, and then they'll issue the award. So the closure really doesn't have that much impact. Other institutions are different. And the most notable one is ICC. And I think we have something to think about here. What ICC does under 27A is once closure happens, and they actually define when closure should happen. Closure should happen after the last hearing. That's the date. Or the last filing. So it's whichever is later. So that becomes your benchmark. And once you have closure, the tribunal basically is supposed to provide an estimate of how long it's going to take for the award. So you have this benchmark, and then you have this burden on the tribunal. They have to provide an estimate. So my thinking was, and you have this similar mechanism basically at the WTO and at Stockholm Chamber of Commerce, you shift the burden, if you may, to the tribunal. So the tribunal basically has to prove or provide some kind of reasoning as to why they're taking so long and when they'll be finished. So I'm thinking that this is something that maybe ICSID could do. And by doing this, it would shift the burden on the tribunal. So what we could do, for instance, is define, like they do in ICC, when closure occurs. So it could be, for instance, when the last hearing occurs or when the last filing is, which is usually a lot of times the statement of costs. So at that point, closure is triggered. And then the tribunal would perhaps have to provide an estimate. We're going to need 30 days, 60 days, 90 days, whatever. And then they'd have to provide an explanation. So I thought this might help kind of shift the burden and move the process along, because we have a lot of concerns that some tribunals are taking too long. And there are many reasons why, but this might help us, the parties and the states concerned, to get a sense of when they can get their award. Thank you very much.
Thank you very much, Jean-Guy, for this very insightful presentation that is based on solid empirical research. Just a follow-up question for you. How would you go about, would you make an amendment to the rules? Would you put that in the procedural organization of the hearing? How do you see that as a practical way forward?
Yeah, I think putting it somehow, making it more concrete, I think would definitely provide more transparency and guidance for everybody involved, and more predictability. So some type of mechanism, whether it's the procedural order or amending the rules, I think could definitely be a solution. Yeah.
Thank you very much. It's my great privilege now to move to my colleague Bart Leghem, who's a partner at Dentons in Paris. He's the former chief of the NAFTA Arbitration Division, Office of the Legal Advisor in the Department of State. And we're extremely privileged to have Bart's contribution because it's a think piece that is based on a lot of thought that has evolved over time, and you were the first one really looking into a possible appellate mechanism to be included in, or that was included into the US treaty model in 2004. And you have your views about an appellate mechanism, and you share with us the way you see an appellate facility being brought back to the table in the changed circumstances that we're facing. And so we are very privileged of hearing from you about an appellate mechanism for investment arbitration. Is it worth a second look for the Trans-Pacific Partnership and the proposed EU-US FTA? You have the floor, Bart.
Thank you very much, Anna. I count myself among the critics of the first round of proposals for an appellate mechanism for investment disputes. When the idea was first raised back in 2003, I published articles noting the many challenges that stand in the way of an appellate mechanism and noted that the case had not yet been made for its need. Two important initiatives today provided different contexts for an appellate mechanism. Together, the proposed Trans-Pacific Partnership and Transatlantic Trade and Investment Partnership, the awfully acronymed TTIP, these two agreements will join over half of the world's gross domestic product under agreements that are likely to resemble each other in important ways. While I am not yet persuaded that an appellate mechanism is needed, I argue in the short opinion piece published in the book that these two initiatives provide a context in which a second look at an appellate mechanism may be useful. Now let me begin with why an appellate mechanism is a bad idea. 3 points. First, the environment of current international investment law is not well suited to an appellate mechanism. This environment consists of over 3,000 investment agreements negotiated between different states over a 50-year period. In this environment, an appellate mechanism would have little ability to achieve the coherence and consistency that its proponents have argued would be its crowning achievement. Nor would consistency be the desired outcome for the many states who have devoted substantial resources to developing a new model of investment treaties. They've done that precisely because they don't want their treaties to be construed in the same way as the treaties concluded by other states a half-century before. The diverse nature of the contemporary investment law environment cannot promote a truly consistent and coherent mechanism by a common appellate body. Now, this contrasts with the environment where the rare examples of international appellate mechanisms have been successful, such as the WTO appellate body or the appeals chamber of the International Criminal Court. These mechanisms address multilateral agreements with identical texts for all contracting states, a markedly different environment from that of contemporary international investment law. Second, the cure here could be worse than the disease. The wrong sort of appellate mechanism could do irreparable damage to international investment law. Consider, for example, an appellate mechanism that viewed itself as a sort of constitutional court with a broad mandate to protect investors and which ruled consistently in favor of the investor position in every case before it. As another example, consider an appellate mechanism with a majority of members appointed by developing states under a one-state, one-vote approach, which consistently sided with the state in every case brought before it. Either one of these would be a disaster for international investment law and a significant step backwards from the current system. The stakes, I submit, are sufficiently high that an appellate mechanism could be justified only if a compelling need can be shown for it. Third, that need has not yet been established in my view. The cumulative number of investment treaty arbitrations resulting in a final award today over history is less than what a single judge in a New York state court handles in 1 year. The base of experience, I would submit, is too limited to permit a definitive conclusion. And those cases that are most often held up as examples of an inconsistency disease requiring a cure, the Lauder and CME cases against the Czech Republic, most notably, would not be cured under any known appellate mechanism in international practice. The existing international appellate mechanisms address only the erroneous application of the law to the facts. They do not address differences in the appreciation of facts by the tribunal of the first instance, as was the case in the Lauder and CME arbitrations. Now, some of the arguments against a general appellate mechanism for investment treaty arbitrations would not hold for one addressed to the Trans-Pacific Partnership or the Transatlantic Trade and Investment Partnership. First, if successful, these negotiations, or each of these negotiations, would individually result in a unitary agreement capable of consistent interpretation. This is the sort of environment where the goal of consistency in interpretation could be achieved. Second, TPP and TTIP present environments in which the interests of the negotiating parties may be sufficiently aligned that achieving a well-balanced and functional appellate mechanism may be possible. Experience to date shows that investment arbitrations track investment flows. Each of the TTIP and TPP negotiations include states that are significant investment exporters as well as significant investment importers, at least at this stage of their evolution. Because the principal capital exporters are also substantial importers of capital from the other parties to the negotiations, all parties are at equal risk of investor-state arbitration. There should be a common interest in a well-balanced dispute resolution system that achieves the intended investment policies without favoring either investors or states. Now, I don't mean here to minimize the difficulty of achieving a functional appellate mechanism. This will be a complicated task. My point is merely that it may be marginally easier in this context than in broader multilateral contexts. Finally, given the size of investment flows implicated by these two agreements, it is possible that there will be a sufficient volume of arbitrations brought under either agreement to justify the transaction costs of establishing an appellate mechanism. So where does this leave us? Now, as discussed earlier, some of the arguments against a general appellate mechanism do not hold for TTIP or TPP. This makes worthwhile a reconsideration of the appellate mechanism in this context. A number of the criticisms of appellate mechanisms do, however, continue to hold. Crafting a sustainable, well-balanced appellate mechanism will be devilishly difficult. The case that the existing system is broken and needs a fix has not been made out. The wrong kind of appellate mechanism could produce a system that, unlike the current one, does not work. Weighing the pros and cons is further complicated by the difficulty of identifying who exactly would benefit from an appellate mechanism. The most straightforward answer to this puzzle is that the party who lost before the arbitral tribunal would benefit most, because investors have historically lost more cases than they have won. Investors would appear marginally to benefit more from states, more than states. Now, an appellate mechanism would benefit investors in another important way as well. Under the current system, an investor who succeeds on an application to annul an award generally faces the prospect of starting the case over from scratch before a different tribunal. This prospect is so daunting that most investors do not even try to seek annulment, unlike respondent states. This is likely because the cost of redoing the arbitration, the high barrier to annulment, the additional delay before a final award in a resubmission proceeding, and the uncertainty of winning a second time a case that the claimant lost the first time all add up. An appellate system in which the appeals body definitively resolves questions of law and remands to a first instance tribunal only if questions of fact remain to be resolved could reduce both the cost and the time of further proceedings, as well increase the likelihood of success on review of the initial award as compared to the current system. This would likely benefit investors more than states, which generally are satisfied with the status quo and have no disagreement either with delay before an award that might change that status quo, or procedural impediments that might increase the likelihood of an investor deciding that a claim is no longer worth pursuing. It is somewhat ironic, in light of the above, that many proponents of an appellate mechanism are more attuned to the state's perspective and interests than those of the investor community. For all of these reasons, I personally am not persuaded that an appellate mechanism is necessary and desirable, even in the context of TPP and TTIP. I do, however, think that it's worth a second look. Thank you.
Thank you very much, Bart, for this challenging presentation. Just a follow-up question. The way you approach it, and when you say it could be doable in the context of TTIP or TPP, you see it as part of the treaty, right? The appellate system, the appellate mechanism is part of the treaty. It's not a change in, for example, the rules at ICSID, which would allow in the for the broader system to an appellate system to apply across the board. You see it for those treaties that have achieved or where there is a possibility of more consistency among the rules, right?
Well, I think you could do it either way, but it would be easier to do it as part of the TTIP and TPP negotiations for some of the reasons that I've set out. That being said, of course, the transatlantic trades, it seems like it's becoming more like the transatlantic trade and maybe investment agreement these days. So we'll have to see whether there's sufficient energy on the part of the negotiators to try to deal with an appellate mechanism as well as all of the other challenging issues that they're already confronting. But that would probably be the easier way of doing it.
Thank you very much. I'm now turning to Ted Posner, who wrote, together with his colleague Margaret Walter, a very interesting contribution to the book on the abiding role of state-to-state engagement in the resolution of investor-state disputes. Ted is a partner at Vail, Gottschall and Manges, and in his piece, he analyzes the role of state-to-state interaction and the role it can play when the host state in an investment arbitration resists an arbitral award against it or resists going to arbitration in the first place. And then he brings us closer to the international trading system and tries to see what lessons one can learn or what experience could be brought into the investor-state dispute settlement system. You have the floor, Ted.
Thank you, Anna, and thank you, Jean, as well, the two of you, for your tremendous work in putting this volume together, as well as thanks to Meg and to the Wilson Center. I'd also like to recognize my co-author and former colleague now at the State Department Legal Advisor's Office, Margaret Walter, for her effort in this chapter. I recognize that the theme of this panel is reform of the investor-state system, and so there's some suggestion that we be prescriptive in our remarks. My chapter is largely descriptive. I'm describing a phenomenon that perhaps hasn't gotten the recognition it deserves, to the extent that there's a kernel of prescription here. It's that we be cognizant of this phenomenon, that we must be cognizant of this phenomenon as we think about ways to reform the investor-state system. And in describing that phenomenon, let me start by sort of setting the stage with the conventional story we tell ourselves about how we got to where we are today. It's a familiar story. We talk about the old days, the bad old days, when if an investor were aggrieved by some action of a host state, its only recourse was to turn to its home government and ask its home government to espouse its claim or have recourse to other tools available to it to resolve the dispute on its behalf. And out of this this system emerged the concept of investor-state dispute settlement, the idea being that home governments didn't like being put in this position of being sought after to espouse claims. It was costly. It imposed not just a financial cost, but also a political cost. And home governments wanted to get out of the game of settling disputes on behalf of their investors. And so this concept of investment arbitration, in which the investor, the claimant, is in the driver's seat, emerged and is viewed, I think, certainly by those in this room, as largely successful. And home governments have now gotten out of the game. They don't provide diplomatic support or other or play any other role in the dispute settlement process other than really at the margins or in a very indirect way. In broad brushstrokes and in recognizing that this is in some sense a gross generalization, that's essentially the story we've told ourselves. What I want to suggest is that the story is much more nuanced than that, that there are, to allude to current cinema shades of gray here that we need to take into account, and that really the role of the investor's home state in resolving the dispute writ large, thinking about dispute settlement not just as the arbitration process, but everything from the initial consultations all the way to final resolution of the dispute. The role of the home state is more significant than that conventional story would lead us to believe. And as Anna said in her introduction, the way I conceive of that role is really sort of in three different modes. One is the role of home government as enforcer, helping the investor to enforce its award in the event that there is an arbitral award in favor of the investor. The second role is one that Tomoko alluded to in her remarks, and that's the role of the state as gatekeeper, a role that I think we're starting to see with increasing frequency. I'll talk about this in a moment. One sees this, for example, in a number of China's recent bits. So state as gatekeeper. And then the third role, and the one that really intrigues me the most, is the state as alternative claimant. Sort of back to the future, if you will, in the sense that there may be circumstances, and increasingly frequent circumstances, in which state-to-state dispute settlement, a la the WTO, may be preferable to resolving a dispute to investor-state dispute settlement. Somewhat counterintuitive. Again, the conventional wisdom is that all things being equal, the investor would prefer to be in the driver's seat, would prefer to control the course of the arbitration and the dispute settlement more generally. I would contend that there may well be circumstances in which that's not the case, in which an investor might well prefer to have its home government be its advocate, and I'll discuss that at the conclusion of my remarks. So let me sort of touch on each of these categories very briefly so you understand the phenomenon that I'm describing. First, state as enforcer. One of the things we talk about when we talk about investor-state dispute settlement is the remarkable frequency with which losing respondent states comply voluntarily. And certainly when we describe the system to people who are unfamiliar with it, we frequently talk about that aspect of the system as one of the shining features of the system. And yet, we are seeing circumstances where a losing respondent state declines to voluntarily comply, notwithstanding its obligations under the underlying BIT or the ICSID Convention or other relevant international instruments. Here, the case of Argentina comes to mind, where, as famously or infamously is known, Argentina lost a number of cases over the past decade, failed to comply voluntarily, and claimants' creditors now found themselves in the position where it's quite difficult to enforce compliance. A number of those U.S.-based creditors, one of which I was closely involved with, came to the U.S. government at their wits' end and said, what resources do you have available to you to bring about compliance on Argentina's part? What they ultimately ended up doing was seeking a suspension of trade preferences that Argentina receives under the generalized system of preferences. The United States, in fact, acceded to that request, suspended Argentina's trade preferences. Ultimately, with 3 of those creditors, and perhaps more, I know of 3, Argentina ultimately settled. Is there a cause and effect relationship there? I'd like to believe that at least there was some influence of the suspension of trade preferences. And so this is an example of what I mean by state as enforcer. We're seeing another example of this now in a somewhat different mode in the Chevron versus Ecuador dispute, where there have been certain interim awards issued against Ecuador, which Chevron contends Ecuador has not complied with, and Chevron has now sought suspension of Ecuador's trade preferences as well. Stay tuned for that. Since the U.S. generalized system of preferences has been suspended for the past year and a half, awaiting congressional renewal, we'll have to see where that goes. But this phenomenon is one that we clearly are seeing with increasing frequency, the state as enforcer. State as gatekeeper. Here I have in mind, again, the sort of thing that Tomoko was describing earlier. Situations where a claim is brought and the home government is called upon to perform some role in deciding whether that claim can move forward. This has been sort of a fixture in BITS for quite some time when it comes to tax measures. So a claimant brings a claim of expropriation or a claim of denial of fair and equitable treatment with respect to a tax measure, and before that claim can move forward, there's some consultation between competent authorities, so tax authorities in the respective states, to determine whether that claim should be allowed to move forward. We see the same thing in the financial services area, where the respondent state invokes the so-called prudential measures defense. It's common in many BITs to have some mechanism for state-to-state consultation among experts as to whether that kind of claim should move forward. Here, and I alluded to this earlier, it's interesting to see the more recent China BITs. So, for example, China's investment treaty with Canada has, in addition to state-to-state consultations on prudential measures, an opportunity for sort of mini state-to-state dispute settlement to take place in the event that those consultations are unable to conclude with an agreement between the states. There's an opportunity for a state to go to dispute settlement with the other state before you get the claim back on track and moving forward. I expect that this too is something we're likely to see with greater frequency. Again, that home state being drawn back into the dispute settlement process, notwithstanding this notion, this picture that we have in our minds of the home government really being out of the process. And then we come sort of to the third category, and the one that I find most interesting, and that's the home state as alternative claimant. Essentially, the investor saying, I don't want to be in the driver's seat. I'd prefer that you, my home government, be in the driver's seat and bring a claim against the other state. Really quite like what we see in WTO dispute settlement. Now, it's been common for BITs for many years to have state-to-state dispute settlement mechanisms in them. It's quite frequently an article that almost comes across as an afterthought that provides for state-to-state dispute settlement, usually confined to questions of interpretation or application of the treaty. When you compare that article in the typical BIT to the investor state provisions, it really does sort of read as an afterthought and has largely gone unused for many years, although I could well see that changing. Imagine a situation, for example, where the problem that the investor faces is one of denial of market access. So the investor hasn't been expropriated, very much wants to be in the country, wants to be doing business, but is facing some barrier that it finds insurmountable. Investor-state dispute settlement doesn't necessarily lend itself to solving that problem. The solution that the investor is seeking is essentially injunctive relief rather than monetary damages, and that might well be a situation akin to what we find in trade dispute settlement, where the investor would benefit from the home state initiating dispute settlement with the host government. This also might be the case where you have multiple small claims of multiple investors, no one of which is large enough to really justify an individual claimant bringing a case, but where the home government could really step in on behalf of a large group of claimants to try to resolve the dispute with the host government. This might also be the case where the nature of the problem that an investor or multiple investors face is not easy. The damage is really not easy to quantify. When you talk to people, to stakeholders interested in an eventual U.S.-China bilateral investment treaty, the kinds of barriers you hear about with great frequency are not just market access barriers, but so-called performance requirement type measures, localization requirements, problems that make it difficult to do business in that environment, but the solution to which is not necessarily easy to arrive at through traditional investor-state dispute settlement. I think as we see more and more of those problems arising, the prospect of state-to-state dispute settlement being the solution, I would suggest becomes much greater. And I will conclude by saying I think that's something that we shouldn't dismiss. We shouldn't just say that's a feature of a bygone era, and we're now in the era of investor-state dispute settlement, and where an investor has a problem, we've created these treaties precisely so they can solve them. I would suggest that as we think about reform, as we think about the next era in investment dispute settlement, we give serious consideration to breathing new life into the state-to-state mechanisms that exist in our treaties and are likely to exist in the new ones that we negotiate. Thank you.
Thank you very much, Ted, for this challenging presentation you give us, which is really very timely when you look at those states that are revising their treaties and want to or no longer want to have investor-state dispute settlement provisions in the treaties, and then with the shift that we see from BITs to free trade agreements where all chapters except the investment chapter are actually based on this state-to-state dispute settlement. So I think it's a very interesting insight and approach that you're suggesting. So with that, I would like to invite all of you to react, comment, give us your views. We have, of course, many more proposals, suggestions, ideas, developments in the book than the 4 that we put forward to you today. But I'd like to get some feedback from the audience. Yes, please.
Yes, I have a question. Beju Vasani. I have a question for Ted in how you would define home state. So where you would have an investment that's structured through a corporate chain, let's say through Mauritius or Cyprus, would the home state be the investor for the purpose of the BIT, or would it be the parent? If it was the parent, you could see some difficulty in nationality or jurisdiction or some incoherence in the jurisprudence. If it was the investor, i.e. the holding company, then there may be some reticence. Why would Mauritius, for example, use its resources to defend? Right. How would you deal with that question?
Right. So I think as a practical matter, because when we talk about state-to-state dispute settlement, we're talking about a device that looks more like diplomacy than litigation. As a practical matter, it's going to depend on the political willingness of the state to go to bat for the entity that is prevailing upon it. It may be, for example, that a holding company approaches its nominal home government and asks for help, and the home government says, well, you're just a holding company. We don't really feel a strong affinity for you. However, we're aware of other nationals who face similar problems where the economic activity within our territory is more robust, and maybe you brought the problem to our attention, but we're willing to take this on and pursue it, not necessarily on your behalf, because this isn't really a spousal. This is more like diplomacy, and so I think it really will come down as a practical matter to the facts of the case.
Or the treaty covers indirect investment and the problem doesn't arise.
Yes, please.
EY Park from Korea. I have a question to Bart. Bart, you mentioned that the appellate mechanism may not be necessary in the international investment dispute resolution. I agree with you that the whole redo the procedure in the appellate process is not a effective measures to do so. But if you limit such appellate review on a certain area, such as issue of law. So then, wouldn't it be effective to provide a coherent decisions? For example, there are a couple of tribunals' decision on the defense of necessity in the Argentina cases, and a number of tribunal made a starkly different opinions as to how the necessity defense has been determined. But if you have a appellate a mechanism which would consider the same legal issues, wouldn't it be also considered to be quite effective? So what do you think?
Well, I think it really depends on the treaty texts at issue that the appellate mechanism is supposed to be interpreting. If they really are consistent, then of course you could have a consistent interpretation, even if treaty provisions are, well, where treaty provisions really do have both the same text, context, and object and purpose. But the difficulty is in the details, and in the current environment of international investment law, there are many instances where the text sounds very similar, but is intended to have very different effects. Let me give you one specific example. This is from the U.S.-Peru Free Trade Agreement. It requires MFN treatment, quote, with respect to the establishment, acquisition, expansion, management, conduct, operation, and sale or other disposition of investments, close quote. That's the U.S.-Peru Free Trade Agreement. The Angola-UK Bilateral Investment Treaty requires MFN treatment, quote, as regards the management, maintenance, use, enjoyment, or disposal of investments, close quotes. Very similar sounding treaty text. The the U.S.-Peru Free Trade Agreement has a footnote that says this does not apply to dispute resolution. The Angola-UK Bilateral Investment Treaty has a second paragraph that says the provision that I just read to you applies to all provisions of this treaty, including the dispute resolution mechanism. So how can you achieve coherence and consistency through an appellate mechanism looking at these two different provisions when the two different provisions have such a different meaning? That's a question that I ask.
Thank you very much, Bart. I so wish we had time to start a debate about that. Yes, please. Yes.
Hello, my name's Ian Sheridan. I'm a barrister, but I live in Vienna, Austria, not Vienna locally. My question is sparked by Mr. Kim's study, but it could be equally answered by anyone on the panel. Is it the case you feel that brevity as a lawyer's qualities, as a practical point, has been eroded, and that brevity really needs to be championed again? And my point is, I've spent extensive amount of time in financial services. Just a quick example. NDAs, confidentiality agreements, sometimes they would glacially pass, weeks before they were finally signed. And I note that I think JP Morgan has recently got the average time down to 8 minutes. So my question really is to the panel, do they think that there is a practical initiative here for all involved in international arbitration to champion brevity and speed?
As someone that used to live near Vienna locally, I think there's a concern because from the commercial arbitration side, they're generally used to faster awards. So the thought is then, why don't we have this on the investment side? And I think there's the investment side, of course, is very different. And of course, one big issue is the pool of arbitrators, and they're very in high demand, and it's very difficult for that very small pool to generate that many awards in the same amount of time. But if you're, vested in this system, you spent multi-million dollars, both sides, both parties. It's in everybody's interest that you have a good award, of course, but at an earlier time, instead of waiting more than 389 days. Because that just delay, I think, undermines legitimacy of the system and just generates a lot of complaints. So as long as you get a good award, of course.
Briefly, two things. I don't know what Vienna's like. My brother actually lives in Allentown, so it's possible I could end up living in Vienna locally. In terms of brevity, we communicate as lawyers in the abstract. We value people who are able to crystallize things in a clear, comprehensive way. So I'm just think there's a loss of habit there. I don't know how many younger people there are, by which I mean sort of under 30, but it's interesting they are able to compress, and they'll use tagging and links. And in effect, we don't even need to go to the younger people. We all use footnotes in our academic articles. So what's the difference?
Yes, please. And then I'll pass it over to the back of the room.
Kathleen Paisley, Brussels and London. I have a question for Tomoko, following up on what Bart just said, which is, I wonder whether thought should be given to an increasing role for the intent of the treaty parties and the intent of the treaty parties in interpreting treaties. I realize that the Vienna Convention gives a relatively limited role to the intent of the parties in properly interpreting a treaty. It's a US, UK style, a common law approach to contract interpretation is essentially what the Vienna Convention applies to treaty interpretation, which is there for good reason. It's predictability, it's foreseeability, all those good things for parties that were not actually at the table when the treaty was being interpreted, being written. Excuse me. But when we look at the cases that have caused the most problems for treaty parties, which have caused a lot of the concerns that are now leading to the furor that I'm in the middle of in Brussels, it is cases where tribunals made decisions where if the intent of the treaty parties had been given an increased role in interpretation, they would have been decided arguably differently. And I wonder whether, I'm not talking about what mechanism would be used to do that, but whether there's some thought that should be given to whether that's something that create a system for states' parties that would allow them to participate in this process with more assurance that they are going to get what they thought they were bargaining for.
Thank you. Would you like to have a very quick...
Okay.
Yeah?
Okay. First of all, the Vienna Convention part. I think the Vienna Convention adopts the notion of the objectified intention, meaning that intention as expressed in the text of the treaty. But after all, the state parties are the authors of the treaty, and once they clarified the meaning of the relevant provision, I don't see any reason to refuse the effect to their intention, the concordance to the particular meaning to the treaty provision. And the system, you mean the universal system applicable to all the situations? To give more...
I just mean whether it would be useful for arbitral tribunals to think more about the intent of contracting states in interpreting treaties, basically.
The original intention of the parties?
Yes.
I'm not quite sure about that, because the many, like the appellate or ambiente cases, I think the tribunals were dealing with the cases which were not foreseen. The newly emerging issues of interpretation which were not foreseen at the time of the drafting of the treaties. So the original intention of the parties was not simply available, probably, they never discussed about these kind of things, probably, at the time of the drafting of the treaty. So I don't think the tribunals should give more weight the original intention of the parties. Rather, they should probably be, where available, listen to what the state parties now think about the interpretation of the provision.
Thank you very much. There are lots of hands going up, but unfortunately, we will have to close this session because we have to give back the stage, I understand, for a performance that is taking place. Yes, I think I'd like to end by thanking you all very much for your presence here. Would like also to encourage you to purchase this book so that you can get more and more ideas and suggestions that are all equally challenging and practical as the ones that you had on the panel today. I'd like to thank my co-panelists for their excellent presentations, and thank you to Jean to Meg, and to Mark Cantor for joining up in this project that I think was worth the while. Thank you very much. Okay. Well done, guys. Super well
If I
done.
could ask everyone, it's fine to chat with people who approach you, but we need to do it off the
Outside.
stage because they
Okay.
need to